Hello and welcome to the Minimum Competence episode for Tuesday, May 26th, 2026. I'm your host for today, Andrew Leahy, an assistant teaching professor of law at Drexel Klein School of Law. On today's episode, the House Transportation Bill, DOJ's push to restart Trump's Ballroom project, and my Bloomberg column on taxing cloud-dependent software. Let's remember, the tyrant is a child of pride, and read today's legal news. On this day in legal history, May 26, 1868, the United States Senate ended the impeachment trial of President Andrew Johnson, bringing one of the most dramatic constitutional confrontations in American history to a close. Johnson had been impeached by the House of Representatives earlier that year after clashing repeatedly with Congress over Reconstruction. At the center of the dispute was the future of the defeated South and the legal status of formerly enslaved people after the Civil War. Johnson favored a more lenient approach toward former Confederate states, while the Republican-controlled Congress sought stronger protections for freedmen and stricter conditions for reentry. The immediate trigger for impeachment was Johnson's attempt to remove Secretary of War Edwin Stanton, which Congress argued violated the Tenure of Office Act. The Senate had already voted on one article of impeachment on May 16th, and Johnson survived by a single vote. 10 days later, on May 26th, the Senate voted on two more articles, with the result again falling one vote short of the two-thirds majority required for conviction and removal. The final vote of 35 to 19 meant Johnson would remain in office. After that result, the Senate adjourned as a court of impeachment, and the trial came to an end. The acquittal did not make Johnson politically strong, but it preserved the principle that removing a president required more than an intense political disagreement. The trial also tested the separation of powers during a period when Congress and the presidency were fighting over who would control Reconstruction. In later years, the Tenure of Office Act was repealed, and its constitutionality remained deeply suspect. Johnson's impeachment became a lasting example of how legal rules, political conflict, and constitutional design can collide in moments of national crisis. The House Transportation and Infrastructure Committee has advanced a major 5-year transportation funding bill that would send about $580 billion toward roads, bridges, transit, rail projects, and highway safety programs. The measure, called the Build America 250 Act, passed the committee by a 62-2 vote after a lengthy markup and now heads to the full House. The bill is meant to replace the current surface transportation law, which was part of the 2021 infrastructure package and is set to expire at the end of September. Supporters from both parties framed the proposal as a way to keep infrastructure funding moving while giving states flexibility and speeding up project delivery. One of the most closely watched additions is a rail safety package inspired by the 2023 Norfolk Southern derailment in East Palestine, Ohio. That section would require at least 2 crew members on many trains, add inspection requirements, regulate defect detectors, and place limits on certain hazardous material trains. Rail labor groups in the White House have backed stronger rules, while the major railroads argue the proposal is driven more by politics and labor demands than by the causes of the East Palestine crash. The bill would also create a first federal regulatory structure for autonomous commercial vehicles, including automated trucks, buses, and other larger vehicles. Industry supporters say that framework would help the United States compete globally in autonomous transportation, while transit labor leaders say the bill includes important human oversight protections to keep workers involved and improve safety. Another contested provision would impose a new annual federal registration fee on electric vehicle owners, starting at $130 and later rising to $150 to help support the Highway Trust Fund. Backers of that particular provision say EV drivers should contribute to road funding because they do not pay federal gas taxes. Electric vehicle advocates, however, call the fee punitive and argue it would discourage EV adoption without meaningfully solving the trust fund's long-term funding gap. The Justice Department has asked a federal court to lift an injunction blocking work on President Donald Trump's Ballroom project, arguing that a recent shooting outside the White House shows why stronger security is needed. In a short filing Sunday, DOJ said the incident highlights the need for high-level security upgrades at the White House, including the Ballroom, and again sought dismissal of the lawsuit challenging the project. The case was brought by the National Trust for Historic Preservation, which has opposed the project and previously refused to withdraw its suit after an alleged foil attack connected to the White House Correspondents' Association dinner back in April. DOJ had already cited that earlier incident in asking the court to help end the case. According to the Secret Service, the person who fired at a White House checkpoint on Saturday was shot by officers and later died at a hospital. The filing ties the shooting to the government's broader argument that the project is important for national security. And my column for Bloomberg this week, I argue that Tennessee's recent decision in SAP America Inc. v. Gargano shows how poorly traditional state tax categories fit modern software. The court treated SAP's software licenses as non-taxable intangible property while allowing Tennessee to tax cloud hosting and cloud-based services delivered electronically into the state. That split made sense because SAP's products were cleanly separated into licenses, hosting, and cloud services. But I argue that most modern software is not so tidy. Even products that seem local often rely on remote tools for logins, updates, syncing, storage, analytics, customer support, or payment processing. As AI becomes built into ordinary software, the line between software and cloud based service will become even harder to draw. The column focuses on the so called true object test, which asks what the customer is really buying when a transaction has multiple elements. That test works when the taxable and non taxable pieces are visible and separately priced, but it becomes much harder to apply when remote processing is hidden inside a product the customer experiences simply as software. The piece argues that states should adopt a software specific state harbor rather than treating every remote feature as taxable cloud access. Under that approach, software would be presumed to remain software when remote functions are limited to things like authentication, updates, syncing, security, or modest product enhancements. A state could rebut that presumption if the customer is really buying hosted processing, managed infrastructure, AI model access, inference, or other platform level functionality. The point is not to abandon the true object test, but to give it a clearer threshold for hybrid software. Without that guardrail, AI could give states an easy but flawed path to reclassify almost any software product with a remote model feature as taxable cloud access. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading and all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, the prince who is not wise himself cannot be wisely advised.